Good afternoon, Wakili.
Good afternoon.
My name is Caroline Zilani. I am a commissioner. Karibu sana.
Thank you, Honorable Commissioner.
Good afternoon. My name is David Majanja. Welcome.
Thank you, Honorable Commissioner.
Thank you very much, Commissioners, for that introduction. And I'm Sirma. We are going to engage you on your application for the position you have applied of a judge of the High Court. Commissioners will be asking you questions. Before we delve into the questions, kindly confirm to us your county and your ethnicity.
My county is Baringo. I'm from the Lembus sub-tribe of the Kalenjin tribe. Lembus.
Thank you. Commissioner Macharia will take us from here.
All right, just a few questions. This is the second time, I think, to be interviewed for this position. So I can see you've largely been in a private practice. Now, what is driving you into seeking this position of a judge? And in answering that question, could you demonstrate what is it that you think you have that makes you suitable for position, not from a qualification point of view, because you are qualified, but from specific experiences that make you, distinguished as a practitioner and taking into account the many other applicants who are seeking the same position?
Thank you, Madam Chair and Honorable Commissioners. My driving force is what is making me really apply and want to really work for the judiciary is I come from a minority community, that is the Lembus. I want to inspire the young people there so that they can look up to me. We have very few lawyers from my community, and if I get the chance to work here, I believe they'll be inspired and work hard. Another driving force is I have been largely doing litigation for the last 20 years. I have a wealth of experience in litigation. I've honed my skills in litigation, research skills and drafting skills, which I believe it is essential to the role of a judge. Madam Chair and Honorable Commissioners, have had a chance to work for 2 public universities as a council member, whereby, for instance, while chairing, I had a chance to chair a disciplinary committee, which mirrors the role of a judge, where we could hear parties, like hear cases of senior members of staff, and we had to deliver a verdict. I believe I have experience on that. While working for Masinde Muliro University of Science and Technology, I chaired the audit committee, the human resource committee of the council. While chairing that committee, we were negotiating on a long-standing labor dispute on signing of CBAs between the management and the staff. We managed to resolve the agreement, to resolve the dispute, and we signed the CBA. I think that is all I can do.
Okay, so, in expounding on that, you see the challenge you'd have, and not just you specifically, is any applicant. If one enumerates the ordinary, because there's the ordinary that you'll do in the course of your duty, everybody will come and say what they ordinarily do, which is expected of them. Now, the difference is that when you are looking for a judge, you have to show that there's something that is bigger than the ordinary, something extraordinary. That's what now you have to demonstrate to the commission, because at the end of the day, we want somebody who is judge ready, as it has been said. And the commission, remember these are public interviews, the members of the public are also looking at it. And if you end up picking somebody who is not able to demonstrate that, that also paints the commission in a bad light. So it's upon you to prove that beyond that ordinary, there's something extraordinary that you have that makes you distinguished, as I said, in comparison with the other applicants. So what is that extraordinary beyond the ordinary that you've just stated?
In my practice of law, as a mediator, I've managed to have parties who come before me reach an amicable solution within a very short time. That one, Honorable Vice Chair, I think I'll apply mediation, if given the chance, in resolving family matters, especially on succession disputes, where there is a big dispute on the issue of appointment of administrators. I'll use the service weeks to call the parties. We agree from both sides that they choose, from both sides, they give the names for the administrators. That way it will reduce backlog in the family division of the succession matters. And I think there's a report by Judiciary that the court annexed mediation has released, I think, around 56 billion to the economy. So I can say I can bring that. Something else I can bring is I'd propose that we do night courts in plea taking, so that with the advent of new technology, where we've had Judiciary doing the virtual courts, which is doing really well, cases can be done anywhere in Kenya. So for purposes of reducing backlog, I'd propose we do a night courts, and we do it specifically for 1 hour. And that way, we can dedicate the time from 9 to 11 to some administrative issues. And also, given that around that time, the internet is normally jammed. So.
Okay, that's fair enough.
Thank you.
Thank you. Yes, this is Shai.
Thank you very much, Honorable Chair. Ms. Sirma or Mrs. Sirma? Miss. Just a few questions from me.
Yes.
Under the 2010 Constitution, how is citizenship acquired?
I don't think I'm very well versed to that part, but I think our Constitution provides for dual citizenship, so that if you're a Kenyan and now have a citizenship of another country, you can be granted dual citizenship. But I'm not so well versed. Maybe I can refer.
Say that again, that if you're a citizen of another country?
If you're a Kenyan, born in Kenya.
All right.
If you're born
You
in
can
Kenya,
acquire citizenship of another country. That's correct. But the question that I'm asking is, how do you acquire Kenyan citizenship? Not of another country, but of this country.
I think you do an application to the immigration department, maybe.
You're right. That's by registration. And
Registration,
for you to be registered, you need to apply. Any other way that you acquire citizenship? Let me ask you, are you a Kenyan citizen?
I am.
Why are you a Kenyan citizen?
Oh, you can acquire citizenship through registration. You get an ID.
You see, the commissioners are laughing because it's so obvious. So one is through registration.
Okay.
And the other one is through birth.
Oh, thank you. Thank you, Madam Commissioner.
All right. And then out of these two, Which one can be revoked?
The one you apply, the one you acquire through registration can be revoked.
Why can the one that you acquire through birth be revoked?
I need to refer on that, Madam Commissioner.
So the one of registration, how is it revoked? All right, maybe you have not familiarized yourself with the provisions of the Constitution as regards how you acquire citizenship and how it can be revoked if you registered as a citizen. Secondly, we talk of alienated land and unalienated land. What is the difference between the two?
Alienated land is land that has been subdivided and a title document or a certificate of lease has been issued. Maybe under the Land Registration Act and Land Act, or the repealed Land Registration of Lands Act.
So, what is the difference? What is the difference between alienated land and unalienated land?
Alienated land could be a private land, owned by a private person. It can be owned privately. Sorry. Unalienated land could be public land that has not been alienated under the GLA, the repealed GLA.
Actually, it is the other way around.
Thank you.
Unalienated land is one that has not been set aside for a public purpose. And finally, from me, an entity can approach the Supreme Court seeking advisory opinion. Which are these entities that can approach the Supreme Court for the purposes of seeking advisory opinion?
Government
Right.
and any other state organ.
Correct. Thank you. That's all from me.
Thank you.
Thank you very much, and good afternoon again, Madam Sirma.
Thank you.
Yes, we will continue with that line of finding out whether you are a judge ready. If you are successful in this bid and you are sent to a court station, what are the 5 things you would do to make your station efficient?
First of all, thank you, Madam Commissioner, Chief Justice, for that question. First of all, when I'm sent to my new station, on day 1, I'll call for a meeting for all the stakeholders in that station. And for purposes of making the station efficient, I will engage the stakeholders, say the staff, so that if, for instance, they are not acquainted to some skills, I'll propose capacity building. So by capacity building, you enhance the skills so that for work that is needed to be done can be done effectively. Another thing I can do is, in the new station, is look at the files, the matters before me, and embrace the spirit of stage, so that if a matter requires to be done through alternative justice system, then we dispense with that. If a matter needs to be referred to mediation and other dispute resolution mechanisms, so that we can reduce backlog. Mm-hmm. I'll also engage the lawyers so that they don't delay the cause of justice.
Okay, you have sent 4. I think I'm happy with that.
Thank you.
but I don't know how they would make your station efficient. Let's move on now to the practical aspects of the work that you'll be doing, hearing cases and determining them and sieving the evidence. And I'll take you to the Evidence Act. If you can at least tell me 2 exceptions under the Evidence Act when the burden of proof is shifted.
Thank you, Madam Chief Justice, for that question. Under the Evidence Act, the burden of proof will be shifted when an accused person, the prosecution, has not dispensed to the burden, the accused does not dispense with the burden of proof. So it shifts to, sorry for that.
It's okay, we can leave that and go to, you refresh it because it's a key one. It's quite central to your work. Then we go to the Constitution still, and you tell the panel what is the place of precedence or austere decisis in our legal system. And if you can place it in the Constitution, I'll be happy.
The place for precedence, the place for austere decisis.
Yeah.
I think that is a common law principle, so that if you don't have adequate law, you refer to stare decisis. If you've exhausted all other, I think I'm stuck.
It's a hot seat, it's okay. Justice Majanja.
Good afternoon.
Good afternoon.
From time to time, you'll be called upon to dismiss a suit for want of prosecution. Can you tell us briefly some of the principles that are applicable before you dismiss a suit for want of prosecution? You have been told either an application has been made, dismiss this suit for want of prosecution, or you are exercising your own motion to dismiss the suit for want of prosecution.
So one of the principles, Honorable Commissioner, is if a case has not been prosecuted for a long time, so you dismiss it for want of prosecution. Another instance is if the parties don't show up in court, then you dismiss it.
Any other? Suppose the parties show up.
Okay, you'll have given notice.
Yes, they've shown up. So what are the principles?
If, for instance, the matter does not is not a prima facie case or does not raise.
Okay, you read the principles, eh?
Yes.
What is the leading case on preliminary objections? The leading case when you hear the court saying or advocates raising a preliminary objection, there is a case they normally cite.
Okay, so biscuits.
Yes.
I don't remember the citation.
Okay, what was the case about?
I can't remember the facts.
Okay, and who said what in that case then?
Okay.
Or what was said in the case?
I can't remember.
Okay, thank you, and I wish you well.
Thank you.
Yes. Thank you, Honorable CJ. Counsel, I've seen your CV, and you said in your CV you have set out the areas of law where you have practiced for so many years.
Yes.
and you have experience in. You have also been a member, council member of Meru University,
Yes.
and then you have been also at Masinde Muliro University. As a member of the council or as a
Member of council.
member council? Okay. When were you there in Masinde?
2017 to 2020.
Okay. Yes. Are you aware of a dispute involving students of Masinde Muliro campus or university? You know, when it started, Masinde Muliro,
Yes.
it was part of
Constituent College.
it was part of Moi University,
Yes.
right?
Yes.
To the campus.
Yes.
You know. And then Masinde, when the charter was given to Masinde,
Yes.
the university took over the students of Moi University.
Mhm.
Do you know anything about the dispute about those students taken over that time? Which of the two universities should award the degree?
Should be Moi.
Hmm?
Before the award of charter, it should be Moi University.
Yes.
Yes.
But there's a dispute where Masinde purported to give degrees to students whom they found who were there at the time of the charter. Do you know the details of the case?
I don't have.
Okay.
Thank you.
Then I will not go very far because it was before the courts. Okay. You are aware of the blueprint of the Honorable Chief Justice when she took her tenure?
Yes.
About stage.
Yes.
Okay. Give me some of the principles or the tenets of that blueprint.
The first principle is accessibility and efficiency.
Hmm?
Accessibility and efficiency.
Accessibility.
So that, do you want me to explain?
Social justice, it says social transformation through access to justice. How do you understand the concept of social justice in law?
Social justice, I think it's about fairness.
About?
Fairness.
Mm-hmm. Okay.
Yes.
And what about economic justice? Have you heard of anything to do with economic justice? Okay. Okay. Access. Give me examples of access to justice that has taken place since the 2010 Constitution was promulgated.
I think we've had an expanded.
Thank you. That's the word. Mm-hmm.
We've expanded. We've opened. The judiciary has opened more courts. It has taken courts near the people. For efficiency, I think we have virtual courts and automation.
Okay. Yes. You did some labor cases, employment.
Yes.
Okay. The remedy of reinstatement. In what situations can they be? Are they recommended? Reinstatement in the private sector.
I don't quite remember.
Okay. Public sector. Reinstatement as a remedy. Meaning employees of the public institutions seeking reinstatement as a remedy.
I'm not getting the question.
Huh? Okay.
Maybe you can rephrase it.
Reinstatement is a remedy.
It is a remedy. Yes.
In public sector, it's quite common because of the institutions where the employer is the government or the county. But in private sector, it is an individual or a corporate body. Where is it most suitable, the remedy or reinstatement? Can it work in the private sector?
It's a bit difficult for it to work in a private sector.
Why?
Reason being, I think there'll be a bit of friction between parties. So even if you reinstate,
Yes.
the employee won't be able to work well,
Yes.
discharge their duties.
So what would you
And
recommend in such a case where it's difficult to enforce?
You pay for damages or compensation.
Okay.
Yes.
Okay. Which area do you think now that you say you come from is it Lengus?
Lembus.
Yeah?
The Lembu subtribe.
Lengus tribe. Can I be honest? This is my first time, and I'm going to learn more about it. I know the other groups among the Kalenjin. Okay.
Yes.
Thank you very much. All the best.
Thank you.
Thank you, Chair. Good afternoon once again, Council.
Good afternoon.
When the Vice Chair asked you why you are fit for this position, the first response was that you come from a minority community, and the second response you said that you have the relevant experience. In terms of hierarchy, where would you want the Commission to gauge why you're qualified for this position?
I think it's the experience.
It's the experience.
Yes.
Okay, thank you. You also mentioned, I can't remember in what response you're making to, with regards to the issue of AJS, engaging elders to resolve disputes. We have what is called the agency theory of jurisdiction. What is the agency theory of jurisdiction, according to your understanding, with regards to AJS?
Sorry. Thank you, Madam Commissioner, for that question. The agency theory of
Yes, of jurisdiction.
Looks into the cultural norms of the community, so that when a case is applied, when AJS is applied in a matter, then what you consider is the cultural values of the community and their way of living. So you look at the culture.
I think you should look that out in terms of what it actually means, and what are the sources of international law. Sources of international law.
I think under Article 2.5 and 2.6, we have the international rules. We have the treaties and the conventions.
Okay, there is the treaties and conventions
Ratified in Kenya.
But I'm asking within the context of international law, not just specifically for Kenya, because I have a question I would want to ask after you've responded to it. So one of it is conventions. The second would be?
Customary law.
Yes. And then we have general practices acceptable by law, general principles of law recognized by civilized nations, and judicial decisions or teachings by qualified jurists. So if you look at Article 2.5 of our Constitution, general rules of international law form part of the laws in Kenya. In terms of hierarchy or the place of this particular provision of the Constitution in the sources of international law, where would you place it?
I think when you have a gap in our laws and statutes, then you resort to international law and treaties and the rules.
Okay, I don't know whether you've gotten my question.
Okay.
We have just highlighted the sources of international law. You mentioned international conventions, the customary law, practiced and accepted world over. We have the general principles of law recognized by civilized nations, judicial decisions and teachings by jurists. So where would you place Article 2.5 in terms of the general rules of international law?
I think I need to refer. So.
Okay. Thank you and all the best. Thank you, Chair.
Thank you, Chair. Good afternoon once again.
Good afternoon.
Now, we have been interviewing candidates here, quite a number who are from outside and quite a number from within the judiciary, majorly magistrates. And what they have been saying for themselves is that if we picked them, they would be an asset in that court because they are some kind of plug and play situation. It's something they've been doing all along, judicial work, and they won't have a very long learning curve. Now, you are from practice. You've been practicing. What do you have to say for yourself that should give you an edge over them?
What I can say is, when dealing with my work, over the 20 years of practice, I've honed research and drafting skills, so that when we're doing case management, I'll be able to sieve like matters that require to go to the court and next mediation.
Okay, that is something we're already doing as a matter of course in the institution. Let me go to the second part of the question. So backlog is an issue we've been preoccupied with for quite a while. We are coming up every time with innovative ways to address backlog in the judiciary. Can you mention a few of those innovative strategies we've tried to apply to address backlog? Can I repeat?
Kindly.
Yes. What are the strategies the judiciary is employing in trying to address backlog?
Okay. The vision in STARG provides for alternative dispute resolution.
So employing ADR is one of them. Any other? You've been referring to them as you are engaging the other commissioners. The things we are doing to address backlog.
Ensuring that you don't allow advocates to take many adjournments. Engaging virtual courts, of which it's actually happening now. It's very effective. Engaging what we call mahakama popote.
Yes.
Whereby you'll have a judge doing virtual courts in another station to reduce backlog.
Yes. There's something you had mentioned earlier, service weeks.
Oh, service weeks, sorry.
I don't know why you don't want to mention it now, but that's one of the strategies. So now, could you just briefly explain to us how a service week works? How do you go about conducting a service week?
I think a service week is how you do it. I believe, like in the family court, what happens is you get the stakeholders, the advocates, and if there are any interlocutory applications, like the one I mentioned on succession disputes.
Yes.
If there is a dispute, you allow the parties to agree to dispose of that matter, maybe by way of mediation or consent.
That is what you did in that matter. You did it during a service week? You're referring to the matter you had earlier explained, isn't it? So that one you managed to do it in a service week?
Yes.
Yes. But what essentially normally happens in a service week? You need to... Okay.
Sorry.
Okay. So thank you. I wish you well. Thank you, my lady.
Thank you, Honorable Chair. Council, I will ask you a few questions, 2 questions. So would you tell us what you understand by the following terms in the context of the judiciary? One is judicial independence, decisional independence, and institutional independence.
Judicial independence, the second one, please.
Decisional independence and institutional independence.
I think, thank you for that question. Judicial independence is provided for under Article 161 of the Constitution. judicial independence, whereby a judge is required to dispense of his matters by upholding the rule of law and not allowing to be distracted by any forces, outside forces. Another thing is the office of a judge should not be abolished while he's in office. Another one is the financial independence of a judge, whereby the remuneration is pegged on yes, financial independence, and then security of tenure, so that while discharging his duties, a judge should be protected, should not be liable for his acts, so long as he does it in good faith. For decisional independence, I believe that is that applies to a judge, and it's anchored in the judicial code of conduct on the issue of impartiality. A judge should be impartial, judge should be honest, should uphold professionalism, should discharge his duties without discrimination, the issue of equality.
Closely to that, what constitutional mechanisms exist to ensure that the judiciary is accountable and transparent to the people of Kenya?
I think one of the constitutional mechanisms that ensures judiciary is accountable and transparent is like holding trials in open court, like engaging the court users committee, whereby the stakeholders come and discuss their issues, by reducing the perceived or corruption in judiciary, the perceived corruption or corruption in judiciary.
Have you heard of the Public Finance Management Act?
Yes.
Does it in any way regulate how the judiciary operates?
It really helps. We also have the Audit Act and Public Procurement Act.
Okay. What is the import?
I think those are the statutes that are used in the administration in a high court administration.
Okay. 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 Thank you, Chair.
Thank you, Chair. Now, Madam, I'll ask you one question, but divided into three. Article 22 on the enforcement of the Bill of Rights grants every person the right to institute court proceedings, claiming that a right or a fundamental freedom in the Bill of Rights has been denied, violated, or infringed, or is threatened. What reliefs can the court grant in respect to such proceedings?
Thank you for that question. The reliefs are one, an injunction. The court can issue an injunction. The court can issue a conservatory order. It can issue structural interdicts, which was issued under the Mitubel case. It can give compensation, an order for judicial review.
Okay, I will ask you one question. What is the one thing that, when you look at the institution from outside, you desire to make a change in if you're successful to become a judge? The one thing that you feel is lacking in the institution and you're burning to bring it on board.
One is maybe applying ADR to reduce backlog.
I thought that's already there. Maybe not to your expectation, but it's there.
One is when litigants go to court, we advocates, we really work hard to represent our clients. Sometimes judgments get ready and they are not read out in time. So I would advocate for them to be read within time.
So action with speed, that's what you'd bring on board?
Yes.
Fair enough. Now, what are some of the circumstances that under which a judge may recuse themselves?
Kindly repeat the question.
What are the circumstances under which a judge may recuse themselves from hearing a matter?
A judge can recuse themselves when there is a conflict. There is a conflict of interest in terms of is litigated in that case before.
Mm-hmm.
If is a director in the company that has come to his court, then he recuses himself. If a family member appears before him, he needs to recuse himself.
Mm-hmm.
Yes.
And circumstances that he may not recuse himself? Just quickly, three.
One would be whereby there would be unfairness when he doesn't do that, a miscarriage of justice, sorry, if he recuses himself. Two is where
how would there be a miscarriage?
Where there is no,
when the matter is urgent. Just give me the second one you wanted to give me.
sorry. The second one is where there is no other judge to adjudicate on the matter.
Okay. Fine, I'll take those. All the best.
Thank you.
All right.
Yes, thank you very much, Commissioners, and thank you very much, Madam Sirma. This brings us to the end of the interview, but we always invite a candidate to ask the panel any question you might have.
Thank you, Madam Chair and Honorable Commissioners. I don't have a question, but I just want to thank JSC for shortlisting me for the second time, for affording me this opportunity to appear before you. I want to pray for you that as you deliberate on choosing the best from all of us, God will guide you. Thank you.
Thank you. On behalf of the Commissioners, I also wish you well and encourage you to continue working hard to impact on the society to make sure that we can live in a society that is free and equal for everybody. Because I read your CV, that is your spirit. Keep it up.
Thank you.
We will get in touch with you when we complete the exercise. Like you have mentioned, it's not an easy one because you are one among equals. We are looking at almost 100 candidates for only 20 positions.
Yes.
So we wish you well.
Thank you so much.
Yes, and have a nice afternoon or nice evening.
Good afternoon too. Can I carry this?
Please do. Some momento.